have him. Not only does he provide content that's always current, but a great name, Bill. Did you know that? Did you change your name? Do we have to run an alias search on you for that? Now that I think about it, all these times I never thought of that.
Yeah.
But his content is absolutely current. I'm sure he has remarks that are pertinent. And Bill, I always welcome a conversation with you, because not only is there the content, the brass tacks of what you're trying to accomplish to help employers with the drug testing programs, but you also have an ability to offer some commentary that's relevant for all of us too. So without any further ado, thank you for joining us today and taking us through the content.
Well, thank you very much, Jeff. And just, I'm going to turn my camera off in a minute so we can focus on the slides. But I just want to start out by saying this is part 3 of a 3-part series that we've done together this year, Current Consulting Group with Orange Tree. And I probably, just as a way of background, I probably do, at least 40, but sometimes 50 presentations a year. We do our own CCG sponsored websites as well, webinars as well. But Orange Tree just does such a superb job. And I've actually referred clients to Orange Tree webinars so they can see how Orange Tree does them, because they're just so well done. So I sort of tip the hat to Jeff and his team there on the great job that they do with these webinars. And I think it's so important to do these types of educational events because the facts on the ground are constantly changing. Let me see if I can advance the slides and get to our agenda. I'm going to actually spend a little bit of time just sort of going over some developments since part 2 of this 3-part series to bring everybody up to speed. And then we'll get into sort of the meat of this particular presentation, which has to do with putting a comprehensive drug testing program together. So let me turn off my camera now so we can focus on the slides. Now, everybody knows that the legalization of marijuana is spreading throughout the country. And so here's a map that just sort of visualizes it for you. And let me walk you through this so you can really sort of get a feel for the magnitude of this trend. The states in orange are the states that have legalized so-called recreational marijuana. And the states in blue are the states that have legalized medical marijuana, except for the fact that all the orange states already had medical marijuana. So it's very unusual. In fact, I don't think it's ever happened that a state approved recreational marijuana before medicinal marijuana, with the possible exception of South Dakota, where they implemented both at the same time. And then you see right there in the South, Mississippi, voters in Mississippi actually voted to legalize medical marijuana, but the Supreme Court found a technicality in the process, and so it's on hold somewhat, but it'll be a blue state here very shortly, probably before the end of the year. But what this tells us is that there are about 36 states that have legalized marijuana in one fashion or another. And before I move on to some marijuana stats to sort of bring us all up to speed, I also want to point out that during the national election in November, Oregon voters voted to decriminalize all drugs. And so it's no longer a criminal offense to possess a personal use quantity of heroin or cocaine or synthetic opioids. Now, there are some penalties for having large quantities for, proposed distribution. But generally speaking, all of these drugs have been somewhat legalized for personal use in Oregon. California is looking at similar legislation. Other states have looked at it as well. But it kind of takes us back to the beginning of the legalization movement in the 70s, where it wasn't really about legalizing marijuana only, it was about legalizing all drugs. And then, in the 70s, we went through the sort of the disco cocaine era, and in the 80s, the crack cocaine era. And there just wasn't an appetite for, among voters to legalize all drugs. And so the legalization movement sort of focused on marijuana. There still wasn't much of an appetite for that. So then they sort of focused solely on medical marijuana. And that was their sort of way in. That's where the barriers started to come down. And then from that, we saw the introduction of legislation for so-called recreational, or the more politically correct term nowadays is adult use of marijuana. So this is where we stand right now. And as we think about it, one of the things that we were told early on, especially in the 80s and 90s when the legalization movement really wasn't getting anywhere, was that legalization would not result in more people using marijuana. Well, that didn't seem possible on the face of it, and it's not proven to be the case. Actual marijuana use has gone up significantly during the legalization era. And this is a graph that shows stats from an annual study that comes up from the federal government, the National Survey on Drug Use and Health, which in the old days used to be called the National Household Survey. And this shows data comparing 2018 to 2019 from the report that came out in 2020. I know that's a little confusing, but it's always a year behind. And so the new 2021 report, which will reflect 2020 trends, will come out in August or September. It's always right around that time frame. But look at the significant increase in marijuana use between 2018 and 2019. It went from 15.9 to over 17% in 1 year. That's significant. Now, look over to the left, you see the decrease in the use of, or the admitted use of psychotherapeutic drugs. These are the antidepressants, the anxiety medications, things of that nature. We will probably, in fact, I think I can safely predict that when the 2020 numbers come out from the federal government, we'll see an increase in this category. Because during the pandemic, there are many, many reports and anecdotal reports from various states that show a dramatic increase in the use of various types of prescription drugs or other types of pills, let's say. And we'll see an increase there. We'll also see an increase in marijuana use. And part of that is because, let's see if I can get my, part of that is because the use of marijuana is increasing significantly among young adults. So you see those age 26 or older increased from 7% in 2002 to 15.2% in 2019. That's a dramatic increase during that period of time. And part of that's because the perceived risk of harm in smoking marijuana on a regular weekly basis declined from 38.7% to just under 31% during that same period of time. And this is the real shocker. So past year experimentation or first time use of marijuana increased from 90,000, this is among those 26 and older, from 90,000 to over 887,000 between 2002 and 2019. So the legalization of marijuana, if nothing else, coincides directly with the dramatic increase in marijuana use, with a dramatic increase in the perceived risk of harm in using marijuana weekly. And it's also encouraging people to try marijuana for the first time. Opioid use also went up during the pandemic. 2020 was probably the highest number of overdose deaths from opioids, or most of it attributed to opioids, ever in the recorded history of drug overdoses. And as you see in that last bullet, the New York Times actually referred to the COVID-19 pandemic as a, quote, national relapse trigger, because we were starting to see a drop in opioid use and opioid overdoses and opioid-related fatalities. And then in 2020, as the pandemic took over and people were stuck at home, isolated, cut off from their friends and their coworkers, et cetera, people in large numbers began self-medicating. And that triggered this relapse in opioid usage in particular. And what we saw in the workplace was an increase in positive drug test results. These are just statistics from one laboratory. But as you see in the second bullet, marijuana positives surged in the states with legal recreational laws, 118.2% between 2012 and 2020. That's a ton of increase right there. And that's just in the states that have legalized recreational marijuana use. The overall, the third bullet there, the overall positivity of all drugs increased 3.8% in 2020, was 12.2% higher than 2016. So again, in a short period of time, a significant increase in the number of people who are testing positive in workplace drug tests. So when I get asked the question, should we even continue testing for marijuana? My response is it would be a terribly poor and perhaps even irresponsible decision to drop marijuana from your drug test panel. I know some companies are doing that. And in a survey that the Current Consulting Group conducted earlier this year, about 15% of employers who said they were considering dropping marijuana from their drug test panel said they were considering doing it because testing for marijuana wasn't legal in their state. And that's just not correct information. Testing for marijuana is legal in every state. It hasn't been outlawed anywhere. There are some states with recreational or medical marijuana laws that have placed some conditions on testing for marijuana and what you can do with a THC positive. But every state allows employers to test for marijuana. This is another different drug testing company's experience. Look at the increase in opioid positives and the increase in amphetamine positives just in that one period of time as a result of the pandemic. For the first time in their history, this company reported a higher rate of amphetamine positives than marijuana positives. And both opioid and amphetamine positives were up over 200%. Cocaine down a little bit, marijuana still up about 20%, but opioids and amphetamines up dramatically. So with that in mind, we're going to talk about the importance of a comprehensive approach to addressing substance abuse in the workplace, substance abuse among your workers and among job applicants. Because the truth of the matter is substance abuse is increasing considerably, dramatically, significantly, whatever hyperbole you want to add to it. It's going up and it's having a direct impact on the workplace, which affects a lot of other things. We're going to talk about different doctrines of law that you need to be aware of if you decide to pull back and do less screening of job applicants and employees. So let's start with the sort of comprehensive approach. Years and years ago, the federal government came out with a study that showed that companies that approach drug abuse in the workplace comprehensively, in other words, that they don't simply rely on drug testing, but they include other components of a comprehensive approach, have a much better result, about a 30% decrease in substance abuse compared to companies that just rely on drug testing. So a comprehensive approach would include, first of all, a customized written policy that's specific to your company. I'm going to go into a lot of detail on that. Training supervisors and managers and DERs, et cetera, as well as educating employees on the dangers of drug abuse and how it can affect their lives and their employment. And then drug and alcohol testing, always in accordance with the state laws that apply to you. I get this question all the time. We're in this state, we're headquartered in this state, but we're in 30 other states. Which state laws should we base our policy on? And my answer is all of them, because in each of those different states, you're required to comply with that state's unique drug testing law. And as I'm going to point out in a few minutes, every state's drug testing law is unique and different from all the other ones. The use of certified drug testing laboratories or FDA cleared rapid result point of collection testing devices, always using a medical review officer to verify a confirmed result from a laboratory, an employee assistance mechanism of some sort, whether it's a formal EAP program or providing direction to local assistance that's available within the communities where you have business operations, a critical component, I think, as well. And then making sure that you're reviewing your program, you're reviewing your policy on at least an annual basis. You want to make sure that as state laws change, and they're changing all the time, that your policy reflects those updated laws and you're in complete compliance with whatever the legal requirements are in each of the states where you do business. In 1990, if you can think back that far, I wrote a book called A Guide to State Drug Testing Laws and Legislation. It was my first book that I ever had published. And there were only 16 state drug testing laws at the time. I mean, people thought I knew so much about drug testing laws, but it was easy back then. Of course, I was younger, but it was easy to memorize all of these laws because there were only 16 of them. Today, there are literally hundreds of laws at the state level that impact drug testing. I'm going to take you through an explanation of those here in a second. When you're putting your policy together, you might you might be covered under the US Department of Transportation regulations and have to put a policy together that complies with those regulations. If that's the case, if you have DOT covered employees, the type of policy you put together is very, very specific to those regulations. If you're not covered under some type of federally mandated drug testing program like DOT, then you have to comply with state drug testing laws. Some of those laws are specific to drug testing, and some of them are limited just to certain industries within a state. For example, in Illinois, they have a public works contractor law that requires those types of companies that have contracts with the state for public works contracts, they require them to drug test a certain way. That's the only mandatory drug testing law that exists in Illinois. Outside of that, you can drug test however you want, but you may want to take into consideration workers' comp regulations, unemployment comp regulations, and definitely marijuana laws, because in Illinois, they have one of the more restrictive marijuana laws when it comes to the workplace. Now, when I talk about workers' comp and unemployment comp regulations, it's important to know that in almost every state, those regulations, which are unique to each of the states, allows employers to move to deny a workers' comp claim, for example, if there's a positive drug test result that shows that perhaps at the time of the injury, this person had prohibited substances in their system that may have contributed to the accident. In most of those states, it doesn't necessarily mean that the drug test result is proving impairment. It's just a requirement, sort of a hoop that the employer has to jump through in order to qualify to deny that workers' comp claim. The same in unemployment comp situations as well. Now, these types of regulations, the workers' comp regulations specifically, are different than some states that have what we call voluntary drug testing laws. And I'll get into those, an example of those in a minute. But they also relate to workers' comp claims as well, or workers' comp insurance as well. And we'll get into that in a second. Now, when you're putting your policy together, you want to make sure that you're very clear about what your objectives are with this program. For example, is it to create a safe and healthy work environment for your employees, for your customers to visit, etc.? Is it to discourage drug and alcohol abuse in the workplace so that you have a safer workplace, so that you're not bringing a criminal element into the workplace, to ensure that employees are fit for duty, fit to perform their assigned duties, especially in safety-sensitive work environments? Or is it to educate employees on the dangers of drug abuse, how it affects their health, their home life, or even their employment status, which could affect their career as well? All of those things come into play as you begin to put the policy together. We're going to talk about the specific components of the policy, but before you ever start writing anything for your policy, you need to understand what your objectives are. What are the goals that you hope to get from this? And based on that, you develop a policy, a program, if you will, that makes it possible to achieve those objectives. Now, part of the policy will include when to test. And one of the big questions that we typically get is, should we continue doing pre-employment drug testing in this era, in this period of time when there's a quote unquote labor shortage going on? And the answer, in my opinion, is absolutely yes, a resounding yes. And part of the reason for that is that substance abuse, as I've mentioned, is skyrocketing. So to eliminate some form of pre-employment testing as at least a post, it says post-offer there, that's a typo, it should say post-offer, is critical if you want to make sure that you're not hiring people that have a history of substance abuse. Generally speaking, pre-employment testing is a great deterrent to drug use. Again, the federal government came out with a study some years ago that showed that individuals who identified as being regular substance abusers who were employed full-time, 40% said they were unlikely to take a job with a company that conducted random drug testing, and 30% said they were unlikely to work for a company that practiced pre-employment testing. So as a deterrent, pre-employment testing is very effective. If you don't do pre-employment testing, you're essentially inviting the substance abusers in your communities to work for your company, come get a job with your company. And then you're hoping that later, if there's a problem, you'll catch them with random testing or reasonable suspicion or post-accident. The problem with that approach is that post-accident testing takes place after an accident has occurred. It's important for workers' comp issues, but it doesn't deter drug use. The same to some extent with reasonable suspicion or for cause testing. These are all testing methods that are important and have a vital role to play in your comprehensive program, but they're a testing method that occurs after a negative event has occurred, an accident or violence in the workplace or employee theft or increased tardiness or unexcused absences from work, etc. Those things can trigger a reasonable suspicion test or a post-accident test, but random testing and pre-employment testing deter drug use. They deter drug use, and they also, in the case of pre-employment testing, deter people from applying for a job with your company. Now, there's also, in the event that you're going to give people a second chance, there's return to duty testing and follow-up testing, which are all part of the DOT regulations, but something that many non-DOT covered employers also include in their program. And then finally, there's something we call pre-duty testing or fitness for duty testing. That's when a company either randomly or universally, meaning everybody who comes to work that morning, is selected for a drug test before they start their safety sensitive duties for the day. It's typically something that is done in safety sensitive workplaces. It's a high volume testing method, so it does incur more costs, but in some instances, it's very important because the type of work that these individuals are doing it's critical that they're drug free during the day. Now, we can talk about, if you have any questions about that, let me know. We can talk about, how long does somebody stay impaired by marijuana after use? Most studies show that it's somewhere between 3 and 10 hours after usage. And so there's a need to do a pre-duty test, even for somebody who used the drug, an hour or two before they came to work. That's an excuse, I think, that some people use that really isn't valid, given the fact that there are studies coming out now that show that a person remains impaired or under the influence of the drug long after the intoxication or the high has worn off. So pre-duty testing has a role as well in a comprehensive program. How to test is based on why you test, right? And why you test, as we discussed, towards the beginning of this segment, is the sort of guiding light of your program. So you have choices nowadays. Back in 1990, when I wrote that book, there was just one drug testing method, really, and it was lab-based urine testing. Today, there's lab-based urine testing, lab-based hair testing, and lab-based oral fluid testing. And lab-based oral fluid testing and lab-based urine testing have been officially endorsed by the federal government. SAMHSA has put out regulations on both those testing methods. And last year, SAMHSA issued a notice of proposed rulemaking for hair testing. So really, you have 3 testing methods that have been endorsed by the Substance Abuse and Mental Health Services Administration, SAMHSA. But there are also point of collection devices, sometimes called rapid result, on-site, immediate result type tests. They're usually single-use disposable rapid result devices. And there are a number of these devices that have been cleared by the Food and Drug Administration. They're FDA cleared. So point of collection testing is something that has increased in popularity as well. And as you talk about the different types of tests, you want to choose not necessarily just one, but you want to choose a method, a specimen method that is right for your company, urine, hair, or oral fluid. They're all good. They have all proven to be scientifically sound. And as I mentioned, they're all 3 endorsed for lab testing by SAMHSA. There are significant differences, though, that may be which one you use may be influenced by why you're doing drug testing. For example, hair has a 90-day window of detection. It's great for a pre-employment screening when you're looking at a lifestyle drug practice or drug use practice on the part of this applicant. But drugs don't become detectable in a hair sample for 7 to 10 days after a person's absorbed the drug into their system. So it's not really good for a post-accident or a reasonable suspicion situation. Oral fluid testing, on the other hand, has the ability to detect drugs immediately after usage, because in an oral fluid sample, you're detecting the parent drug and not just a metabolite of the drug. The window of detection with oral fluid is much tighter though. It's usually 2 to 3 days, but the drug is detectable in, let's say marijuana, for example, is detectable in an oral fluid sample within minutes after the person absorbs the drug into their body. Urine testing has a bit of a lag time of maybe 6, 7, 8 hours after somebody uses a drug, because you have to wait for the drug to be metabolized in the body. But then the window of detection at the cutoff levels that we use is usually about 3, 4, maybe 5 days at the most. It doesn't mean that you can't detect marijuana in a urine sample 3 weeks later, but you're not going to detect it at the cutoff levels that employers typically use, especially if you're following federal guidelines. And then another question I get asked all the time is, which drug should we test for? And my response to that is test for the drugs that people are using. Today, we've seen a spike in marijuana use, of course, from year to year to year since 2012, but we're also seeing, as I mentioned, a dramatic increase in opioid usage. So we're talking about synthetic opioids, but also amphetamines. And so I wouldn't drop cocaine from your panel, but I definitely wouldn't drop marijuana from the panel either. And if you're not testing for opioids or an expanded opioid panel, I would probably consider adding that, just because of the dramatic increase in opioid usage over the last couple of years, especially since the start of the COVID-19 pandemic. And then how you do the collections is important, the confirmation testing through a laboratory, and the medical review officer. And all of these things are going to be covered in your policy. Your policy will explain how you do drug testing. And then the question becomes, what now? When you get a result, what are you going to do with it? My first point of advice here is make sure you check with the state laws that apply to you, because the state laws are different from one state to the next. And so you want to make sure that what you do with a positive drug test result is in compliance with the state laws that apply to you. Your choices are either to hire or not to hire an individual in a screening situation before they become an employee, or some type of disciplinary measure, suspension, termination, second chance agreements, excuse me. And then you want to take into account the legal considerations beyond what the state laws say. So let me give you an example here, especially for a company that may be considering dropping marijuana from their drug test panel. 2 doctrines of law, respondeat superior and negligent hiring, hold employers responsible for the acts of their employees when they are performing within the scope of their employment. Let's say, for example, you hired someone to drive a delivery van. When that person is on the road making a delivery, they represent your company and you're legally liable for their acts. If they get into a car accident, if they hit somebody, if they cause property damage, or heaven forbid, something far worse in terms of harm to an individual, your company can be held responsible for that act because they're operating within the scope of employment. So let's say, for example, you drop marijuana from your drug testing panel and you don't have any clue whatsoever that you just hired a regular marijuana user. So that person now is driving the delivery van and they get high every morning before they come to work. Well, that high, which is especially acute right at the time that they're smoking the dope and for some minutes afterwards, the high wears off, but the impairment effect of the drug continues for hours after the individual is no longer feeling intoxicated, meaning they may feel normal, but in reality, some aspect of how they perform is being impaired by the lingering impairment effects of the drug that they smoked in the morning before they started working. So they get behind the wheel of your delivery van, not realizing or not feeling like they're high anymore, but they're impaired. And if you did not know that you hired a regular marijuana user and you put them behind the wheel of that car, that essentially increases your exposure to legal liability. So you wouldn't want to discontinue pre-employment testing. You wouldn't want to drop marijuana from your drug test panel. And you wouldn't want to put somebody behind the wheel of a delivery van or a forklift or some other heavy machinery if you had the chance, if you should have or could have known that they were a substance abuser before you hired them or before you put them in a safety sensitive position. So what you do with a positive result may be affected by state laws, but you can avoid these problems even before you find yourself in a position where somebody who is impaired by drugs commits an act that is going to cost you a lot of money because you're going to be held legally responsible for that. You can avoid having to make the decision to terminate that person by perhaps not hiring them in the first place, or certainly not putting them in a safety sensitive position. And part of that weaves into the importance of educating your employees and training your supervisors. The purpose of that is to keep everybody on the same page when it comes to your drug-free workplace program, to your comprehensive approach. So you're going to train your supervisors and managers, you're going to educate your employees, you're going to train your designated employer representative, your DER if you're under the DOT regulations. You're going to base it on something called reasonable suspicion training that doesn't ask your employers, or your supervisors, I should say, to diagnose substance abuse issues, because that's not what they do. They're not really trained for that. You can't really provide training that makes it possible, but you can help them understand reasonable suspicion situations that may or may not be tied back to drug abuse, but by your company policy might trigger a reasonable suspicion test. And when you do that, it puts the supervisor at ease. It helps them to understand that they're not making the final decision about whether or not to fire or hire somebody. They're simply doing their job as a supervisor and observing job performance. And when they see something that's aberrant, that's out of the norm, that's out of the norm, that doesn't jive with the individual's normal behavior in the workplace, or makes it difficult for them to do their job properly, they're going to know what to do in that case when it comes to drug testing. They're not accusing anybody of anything except observing this aberrant behavior that by your policy should trigger a drug test. And they're going to know how to make that happen. They're going to know how to get the person to the collection site, or how to administer the on-site rapid result test if you're doing that, essentially. But it alleviates the tension that sometimes exists when you ask employers, or when it creates an unrealistic expectation for a supervisor to do something that he or she is not really qualified to do, which is to diagnose some kind of substance abuse issue. And as I mentioned earlier, with employee education, you're helping your employees understand not only do you have a program in place, which the majority of your employees are going to be very happy to learn, but they're going to understand how it affects them personally. They're going to know what triggers a drug test. They're going to know what kind of drug testing you do, et cetera, because it's all included in your employee education program. Now, you can do the training or the education with on-site in-person training, or there are many online courses that are available that offer certifications to employees and supervisors when they complete the courses. And then those certification notices go into their employee file so that you have it on record that you did train them, you did provide this information. You may even repeat it from year to year just to make sure that it's fresh in their minds what the company policy is. And if you should change your policy, which is what we're going to talk about now, you want to make sure that you notify your employees of any changes to the policy. Okay. So I said earlier I'd talk more about state laws. In the interest of time, I'm not going to spend a lot of time on these next two slides, but it's important to know, as I mentioned, there are mandatory laws and voluntary laws. There are 16 states actually that have drug testing laws that are voluntary in nature. For example, here in Florida where I live, employers can enter into a workers' comp premium discount program from the state that gives them a 5% discount on their workers' comp premiums if they drug test, and if they drug test in accordance with this voluntary law in the state. Outside of that voluntary program, here in Florida, we don't have a mandatory drug testing law. So employers can drug test as they wish. But as part of the voluntary law, there are certain requirements that the employer has to meet. And this is true in other states with voluntary laws like Tennessee or Alabama or Georgia, just to name a few. But if you're in one of those states and it's important to you to qualify for that workers' comp premium discount, which in some states is higher than 5%, you want to make sure that you know what those requirements are and that you officially enter the program so you qualify for the premium discount. In addition to state laws, however, there are case law developments in virtually every state. California is a good example of a state that doesn't actually have a drug testing law, but probably no surprise to anybody on today's call, there is so much case law in the state of California. In other words, people being sued and employers being sued and defending themselves, that all of this case law sort of forms a de facto course of action when it comes to drug testing. And this is true even in states that have mandatory and voluntary drug testing laws. So you want to make sure you understand also what the case law says about drug testing in your states. We talked about workers' comp and unemployment regulations that actually allow you to move to deny workers' comp benefits. But also in some states like Utah, they have a program that offers employers who drug test a certain way as prescribed by the state, limited legal liability from being sued by an employee or a job applicant when the employer can prove, according to the state regulations that they followed, that they acted in good faith upon the results of the drug test. And so in some states, Alaska being another one, Utah, these legal liability protection laws are actually very easy to comply with. They're not very restrictive in how you do drug testing, and they offer you a bit of protection there that could really come in handy at some point. As I mentioned, Illinois is not the only state, but it's an example of a state that has an industry-specific law. So if you're in a specific industry, like mining in West Virginia or Kentucky, you want to look at those industry-specific laws, make sure your policy complies. And then, of course, the big bugaboo, medical and recreational marijuana. And a lot of those medical and marijuana laws, medical marijuana or recreational marijuana laws do include workplace-specific language. Now, whatever restrictions may apply as part of a marijuana law in a particular state, Illinois, for example, where they place some restrictions on what employers can do with a positive THC result for pre-employment testing in particular, they do not apply to any companies that are mandated by DOT, by the US Department of Transportation, to conduct drug and alcohol testing. So in other words, if you're in the trucking industry, you've got DOT covered employees, and there's some restrictions on testing for marijuana in a particular state where you do business, these DOT regulations preempt that marijuana law. There are no restrictions. You're still required to test for marijuana as a pre-employment screen and as a post-hire test in reasonable suspicion, random, post-accident, etc. This is very important. While there may be restrictions on whether or not you can hire or not hire somebody who tests positive for marijuana, say in Illinois or Nevada would be an even better example. Under the DOT regulations, you cannot allow somebody to start performing safety-sensitive transportation duties that are covered under the regulations until they produce a negative pre-employment drug test for marijuana, as well as the other drugs that are included in that DOT panel. So if you're in a state with restrictions, the DOT regulations come first. You still have to test for marijuana. You still cannot put somebody behind the wheel of a truck who tests positive for marijuana in a pre-employment screen. Now, as part of your comprehensive program or policy, you're going to start with a purpose statement. You're going to identify who has the authority to send somebody for a drug test, who in the company is covered by the policy, all employees, just safety sensitive workers, etc., whether you have an EAP program, and specifically what type of conduct is prohibited, how you conduct drug and alcohol testing, what the consequences will be for policy violations, and anything to do with marijuana and state-by-state regulations. So you're going to have access to these slides. Anybody on today's webinar can have these slides through Orange Tree. I'm just going to say, as far as the purpose statement goes, I'm not going to go through each one of them. I was only going to highlight 3. Purpose statement, that's the blueprint. That's the thing that tells everybody who reads this policy why you're even doing drug testing in the first place. So that purpose statement is very important at the beginning of your policy. And then it's important that you include language that describes prohibited conduct. For example, you have the right, even in states that have legalized marijuana, to prohibit somebody from bringing drugs to the workplace, using prohibited substances while on the job, excuse me, and being at work under the influence of the drugs. In addition, you can make it a point of your policy to prohibit somebody from testing positive for prohibited substances. And in some states, that alone will be enough for you to take adverse employment action based on the drug test result. Now, there are other behaviors, job performance issues, etc., that can be used in addition to a positive drug test result to take some type of adverse employment action. You want to include the state laws, and as I mentioned, you're going to have a base policy that's usually based on your home headquarters state, but then you're going to have addendums for the individual states whose legal requirements or restrictions differ from what's in your base policy. So if, let's say you're in 30 different states and your company is headquartered in Florida, you're going to write a policy that complies with the Florida law. And as I mentioned, outside of the voluntary law here in Florida, there are no restrictions on drug testing. But you're also in California, Massachusetts, Vermont, New York, New Jersey, Pennsylvania, some of these states that do have restrictions on, or conditions better stated, for drug testing. In California, for example, you're restricted in random testing to safety sensitive workers only. But in Florida, you can conduct random testing of all of your employees. So you don't want to base your entire company policy on the very restrictive conditions that exist in California. You just want to have an addendum that covers California so that in California, your operations are compliant with those laws or those case law restrictions, while not restricting the rest of your company that may not fall under those types of conditions. And then, very important that your policy have a marijuana section in it. Again, that complies with the various state laws that apply to you. If you're a multi-state employer, you may find yourself not wanting to impose the very restrictive conditions that we find in the Nevada medical marijuana law to your entire company outside of Nevada. So you don't want to base your entire program on the most restrictive law, but you can comply with that restrictive law and make sure that your employees in those states comply with it through an addendum that covers that marijuana law. But it's important that you take a stand on marijuana, that you not remove it from your drug testing panel, and that you understand that you have the right to prohibit employees from using marijuana on the job. There is no state law that requires you to allow employees to use marijuana on the job, to bring marijuana into the workplace, or to be impaired or under the influence of marijuana while they're working for you. These rights will never be extinguished. That's something that the pro-legalization people would not try to do. You all will always have the right, and you have that right now, to prohibit those things. If you're concerned, though, about complying with laws and that your policy reflects those marijuana laws in a way that protects you from legal liability, just make sure you comply with the laws that apply to you then. Your Illinois marijuana section will be different than your Nevada one. And it'll be very different from Florida and Texas and most of the southern states where these marijuana laws do not place restrictions on workplace drug testing in most cases. Comply with the laws and just merely require people to not use marijuana at work, to not bring it into the workplace, to not be impaired by it, and to do their job. If you will comply with the laws, you have no worry. Even if somebody did bring some type of legal action against you, it wouldn't hold up because you'd be able to show that you comply with the local laws that apply to you on a state-by-state basis. Just be clear about that, what's allowed and what's not allowed. Okay, and let's, Jeff, I think we must have some questions. Before I launch into this last section, let me ask Jeff, do we have questions that we want to go through? Because I'll make all of these slides available and people can go through these mistakes on their own if we need to get to some questions.
You know what, Bill, it looks like there's just one at this point. So I think if you have some good topics here, this would be a good section to cover today.
Okay, so this section kind of goes over a few things that we've talked about. The first mistake most employers have when they implement a drug testing program is they just don't know why they're doing it. They don't have a vision for what they would accomplish with their drug testing program. They haven't checked the state laws that apply to them. And their policy is sort of a generic one-size-fits-all policy. And that's a very, very dangerous mistake to make because you're required to comply with all of those state laws that apply to you. So make sure before you write anything down that you identify your drug testing objectives and that your policy is based on the types of program components that can help you achieve these objectives. Let's say, for example, you want to reduce accidents in the workplace and workers' compensation claims, right? Well, on the surface, it may seem like post-accident testing is the way to go. But remember, post-accident tests take place after an accident has occurred, after property damage has taken place or somebody's been injured. So a more effective means through drug testing of reducing accidents would be random drug testing, because that deters drug use. That says to your employees, it's not worth taking the risk of showing up to work under the influence of marijuana or any other drug, because I don't want to lose my job. So random testing would be in your policy because your objective is to lower accident and workers' compensation claims. And the average workers' compensation claim today is about $48,000. So that's a good objective to have, especially in safety sensitive workplaces. And then in addition to that, you want to know when to test, right? I think pre-employment testing is still important. I think that entire screening process is important. I wouldn't discontinue pre-employment drug testing, and I wouldn't remove marijuana from a pre-employment drug test panel. Excuse me. But I would make sure that I'm complying with the laws that apply. And that's something Orange Tree can help you with to really improve the candidate's experience through that screening process. But drug testing, when done right, can come across as a very responsible and beneficial thing to somebody who's applying for a job with your company. About 15% of workers, according to the federal government, of full-time workers have a substance abuse issue, 15%. But that means about 85% don't. So the majority of your employees are going to be happy that you have a drug testing program in place, as well as the people who apply for jobs with your company. Remember, 30% of admitted drug users who are employed full-time would not work for a company that does pre-employment testing. So you're screening out those individuals from the get-go. And then not knowing how to test. And we talked about these in more detail. Just make sure you're choosing the testing method that's right for you, or the testing methods that are right for you. There's no law saying that you can't use urine testing for, say, your pre-employment program and oral fluid testing for your post-accident and reasonable suspicion program, or some other combination to get the most out of the benefits of each drug testing method. And then very importantly, as I mentioned already, you want to make sure that you communicate everything in your policy to your supervisors and your employees, and that when you make changes, you update them so that they're aware of the fact that you've just added oral fluid testing to your program, or that you're switching from lab-based testing to point of collection testing, or that you're now doing random testing in Illinois when you weren't before. Keep them up to date on developments with your program so that nobody can ever come back and say, I didn't know, and use that as a defense against a company because they took reasonable action based on a positive drug test result. You just want to make sure that you have a paper trail that shows everybody's part of this program, and we keep everybody up to date on everything that we do as part of the program. Again, in conclusion, a comprehensive drug testing program produces greater drug-free workplace results than a program that just relies only on drug testing. So you want to have those other components in there, beginning with a comprehensive policy all the way through how you do drug testing, when you do drug testing, and the drugs that you test for. Okay, Jeff, so now I'll turn the microphone back over to you.
Thank you, Bill. We had a question come in from Crystal. And what about drug testing prior to a promotion? You have some guidelines, some best practice thoughts around that.
Yeah, that's not an uncommon testing method, especially if somebody is switching to from a non-safety sensitive position to a safety sensitive position, or if somebody's moving up the ladder into a supervisory capacity, where you wouldn't want that individual to have a drug problem and then be supervising employees who don't have drug problems. So that's not an uncommon thing to do. It's not prohibited in, I'd have to go back and check our state law database to be sure, but I would say it's allowed in virtually every state, and not a bad thing to do. Now, under the DOT regulations, for example, if you promote somebody from a non-driving position, for example, into a position that requires a CDL, a commercial driver's license, then that individual has to go through the DOT pre-employment testing process as if they were a new employee. So that is, in a way, sort of a promotion screening test as well. But not a bad idea, probably allowed in virtually every state, and not uncommon.
Bill, there was kind of an adjacent question that maybe you just answered it in remarks, but at the risk of it being slightly different, I'm gonna ask it anyhow, and that is, so with all these states with, recreational and or medicinal. And so an employee goes through the process, they fail the drug test, but they're really someone, especially, maybe I shouldn't extend my own little empathy or sympathy to our employers who it's very difficult to fill open positions. So a person makes a mistake. It's part of they put them into a non-safety sensitive position. And then at a point in the future of their employment, that person then, promotion might be a word, but maybe it's just a lateral movement, really. They go to that safety sensitive position. Is there a thought process there, Bill, that's you shouldn't touch that as an employer, have the person come back in through the applicant process? Or, I mean, can you employ, kind of put them in a holding position and then at a future date, move them into maybe an original job position?
Well, are you talking about a safety sensitive position?
I guess I kind of am, but I'm not the expert you are. So safety sensitive, is that automatically a DOT, or is that automatically some sort of regulation that really, maybe you can put that in part of your answer.
Okay, so a couple of thoughts come to mind. One, if it's DOT, then you have no choice. You have to test them, and if they fail the test, you can't hire them, or you can't hire them to do safety sensitive functions that are covered under the DOT regulations. But generally speaking, and of course, my caveat to this answer is make sure you check with the state laws that apply to you, because there could be something in a state law, or even more likely in a case law in a particular state that might influence that process. So always check the state laws. But I guess generally, let me put it this way. A couple of weeks ago, I was asked to participate in a national podcast with Yahoo Finance. They saw something I wrote, they interviewed me for an article, and then they asked me to do this podcast. And the podcast was on the labor shortage that's sort of crippling hiring in the United States. And during my segment, they wanted to talk about what role drug testing in the workplace was playing in causing the labor shortage. And of course, my response to that is it's not causing any labor shortage. It may cause some people not to apply for a job with your company, and that may make it harder to find people or take longer to find people. But drug testing in and of itself is not the cause of the labor shortage. There are other things in the works, and we don't have to get into those things. But drug testing is not the problem. It does put an employer in a position, though, where he or she has to make a decision as to whether or not they want to hire this individual now without testing them, and then maybe face the consequences down the road that they hired somebody with a substance abuse issue, or more probably prudently, not hire the individual because they didn't pass the pre-employment drug test. And again, depends on the state laws, right? Nevada wouldn't allow you to not hire a registered medical marijuana user who tests positive. So somebody can show up to a job interview in Nevada high on marijuana, and you can't use that as the reason not to hire them. But I think it wouldn't be wise, though, to hire somebody now without drug testing them, and then down the road drug test them, and then base some type of an employment decision on that down the road drug test. It would be more prudent to just test them now, face the consequences of the positive result, hire, don't hire, and take the longer road to finding people to fill those jobs. It's probably from a business standpoint, it's a longer process. And I understand that in certain industries like fast food, it's just so hard to find